Welcome, ladies and gentlemen, and friends out there. This is lecture 3 of our series of lectures on the law of immovable property, or land law, as you may be aware. You saw in lecture 2, we discussed what land was. We looked at the definition of land and the elements or the constituents of land. We discussed fixtures and chattels, the legal principles that govern them. How do you determine if something is a fixture and what if something else is a chattel? We saw all of that in lecture 2. Now, in this lecture, we are going to discuss the interest in land. The first part of the interest in land we'll be focusing on is the allodial interest. Basically, when we say an interest in land, we are talking about the rights that someone or a person or any legal personality, when I say legal personality, it could even be a company, can have in land. The rights that the law would give support or protection to. That is what we refer to as the interest in land. There are various interests in land that our laws here in Ghana provide. So in this lecture, we're going to discuss all those kinds of interest in land. But our first focus here in lecture 3 would be the allodial interest. What do we mean by allodial interest? What are the other interests in land that the laws of Ghana provide? Okay, so if you look at the Lands Act 2020, that was the act that had some of its portions being reenacted. Remember, we've said before in our introductory videos that most of the laws that govern land in Ghana have currently been consolidated into one volume. And that consolidation is what we refer to as the Lands Act 2020, which means the year in which that law came into being or was passed by Parliament and presidential assent was given. That Lands Act 2020 is entitled Act 1036. So in this part of the lecture and subsequent ones, when we refer to Act 1036, we just want you to take notice that we are referring to the Lands Act, that is the current statute that governs the administration and all the matters governing land here in Ghana. Now in the Lands Act section 1, it mentions, amongst other things, that people may acquire some kind of interest in land or some rights in land. Some of these interests that are mentioned in section 1 under the Lands Act are allodial interest, customary tenancy, customary law freehold, usufructory interest, amongst a host of other things. So like we've already said in my introductory part, we are going to look at the allodial interest. What is the allodial interest in land? When we say someone is an allodial title holder of land here in Ghana, what do we mean by that? Now, without much hesitation, let's turn to section 2 of the Act 1036, the Lands Act 2020, to see what the allodial interest is. Section 2 provides, allodial title is A, the highest or ultimate interest in land, and B, held by the state or stool or skin or clan or an individual. So you saw that the first part of section 2A, it says that when we say the allodial title or the allodial interest, it is the ultimate interest in land or the highest interest in land. Now when we say the ultimate interest or highest interest in land, what do we mean? What it simply means by the law is that nobody can claim a superior title to that allodial title holder. So if Mr. A or a company or whoever, a person, has an allodial title in a piece of land, or the interest that the person has in that land is described as an allodial title holder or an allodial interest, what it means is that nobody has a superior interest in that land than he has. So that's the highest level you can go. Okay, that is what we mean by the allodial title, the highest interest, the ultimate, the part that if you get, you say, okay, that is the end. No one has a superior title more than you. We refer to that as the allodial title holder or the allodial interest. Now, the B part, as you saw in the slide, mentions that some individuals or persons can have interest in land that will be of an allodial nature, or we can have some allodial title holders. Who are those? It mentions stools, it mentions clans, it mentions families, it mentions states, it mentions individuals. You understand that? So most of the stools that you have here, like the Asantes have the golden stool, the Achims have theirs. If you go to Ga, some of them, there are stools here in the Ga region. around Accra and other parts. We have other families who also have all that. So all these respective stools or clans have some interest in land that no one can claim a superior title to. So if someone has that kind of interest, we are saying that we refer to that as the allodial title. And the act or the statute is saying that that is the highest form of interest of land that a person can have. Now, the question is that how does someone then even acquire an allodial interest? How does that stool or of clan or family or individual or even the state, how does it or how do they acquire that allodial interest? Let's continue with the readings or the provisions of the Lands Act, Act 1036, still under Section 2, when it mentions something that gives us insight as to what the kind of interest or how a person can acquire an allodial interest in land. Section 2 continues. And it says, and may be acquired through compulsory acquisition, conquest, pioneer discovery, and settlement, gift, purchase, or agreement. So you realize that the Lands Act, Act 1036, or the laws of Ghana provide by statute that an allodial interest could be acquired by an individual through conquest, wars. People, you remember in the olden days, we go around, then they fight, then maybe one tribe will defeat another tribe, then they took over their land. So by conquest, allodial titles are granted or are held by stools or individuals or whatever. Then also mentions by pioneer discovery. Pioneer discovery means that if the person or group of family or clan, they were the first people to discover that land and settle on it. There was no any prior interest, or we didn't have persons who were already occupying the land before they came. They were the first. Pioneer discovery. Then it also mentions gift. So someone could have an allodial title or allodial interest in a piece of land, and that could have been acquired through a gift. It also says that a purchase. So all of these forms give rise to allodial interest. Now, let me give you or share with you some bit of history into our legal system as to how some of these definitions that we are having presently in the Act 1036 came about. Now, a very old case, it was decided by one of the most venerable justices of the Supreme Court in those times, Justice Niyama Olenu, in the case of Amioda versus Pordier. This Amioda versus Pordier case was a case that bordered around lands around Ningo. Okay, Ningo. So there were some factions or some persons who were claiming some piece of land. The others alleged that that land belonged to the Ningos too. Others also felt that no, the land belonged to the family because lands around Ningo were not stool lands but were family lands. It gave the learned justice at the time the priceless opportunity to set down some of these governing principles that today has been crystallized into the Lands Act 1036 as to how we can acquire allodial interest or allodial title holder in a land. Now let's take a bit of the quotations from Olenu Justice as he then was in Amioda versus Pordier. This is what Justice Olenu had to say in the case. He says, land of that description may be acquired by one of four methods. 1, by a war leader and his followers overrunning the land, settling upon it, and apportioning it, expressly or impliedly, among various groups of his followers. You saw the first part of the ratio of the Amioda versus Pordier case decided by Olenu J, as he then was at the time. Now, we are saying that, or the ratio in the judgment mentions that when you have a war leader who overruns a piece of land and settle upon it and expressly or impliedly gives off some parts of those lands to his followers or groups of persons, that can be a manner of acquiring a allodial title. That's clearly, as you appreciate, is consistent with the idea of conquest. And that's how most of the lands that we have in our parts of the country were achieved by most of these tools and individuals. So you have a group and people are fighting for land and other resources. They go overrun a piece of land and people defeat them, capture them, take over the land. When that is done and they're able to conquer the place, that gives rise to an allodial interest. So most of these tools that we have here in Ghana, and the Akan regions, in the Bono regions, in the Ghan regions, they had that kind of history where you had a war leader leading people to go and conquer and take over a piece of land. A very famous case that also is very opposite to this subject is Owusu versus Manche of Labadi. Owusu versus Manche of Labadi. This was decided by the West African Court of Appeal, a very old case. You can look it up on our website, Owusu versus Manche of Labadi. Now, this had to do with lands around Frafraha and La Dade Kotopong area. Okay, so the plaintiff had brought a matter to court, seeking to have the court declare that these lands that the Manche of Labadi was claiming that were last two lands, he said that no, their grandfathers were the ones who waged war and conquered that particular part of the land and settled on it. And therefore, the Manche of Labadi cannot come and claim that those portions of the land are two lands. And the court actually found for him. And this also reinforces the idea that Justice Olenu, and in the case of Dameda versus Porde, also spoke about. And it's important to also note that in that Amioda versus Porde case, when the matter even went on appeal, the Venerable Apalu J, as he was at the time, also concurred on the opinions of the High Court judge on that matter. So that is it. So point one, when you have a war leader overrunning a land, conquering a land, and having the subjects or groups settle on it, that is one way that you can also acquire an allodial interest or title in land. Let's look at the second point, still from the ratio of the Amioda versus Porde, in most of the cases, how an allodial interest can also be acquired. We continue with the ratio in the case. 2. By discovery of unoccupied land by hunters or pioneers of a stew and settlement thereon by the stew and its subjects. So that is self-explanatory too, right? Pioneer discovery. Pioneer discovery. The accounts, for example, they say in some parts of them, either the Asantis or some other sections of them, that some of the lands that some of the tribes found, they got it by pioneer discovery. They were just scavenging and walking around and trying to find new areas of development or subsistence farming, and then they came to occupy some piece of land and they settled thereon. This history is found in most of the traditional stories that is told around many parts of our country. So we are saying that that is also what we mean by the pioneer discovery, a means of acquiring allodial interest in land. Let's look at the third point that we picked from the ratio. 3. A gift made of it to the stew by another stew or authority with perpetual succession. So you saw the third one. A gift that is made to a stew by another stew, okay, for perpetual succession. Now, sometimes these things are very common. You may have maybe a paramountcy or a stew having a piece of land, and because of benevolence or some other alliance, some kind of a diplomatic relation of a sort, a stew may decide to give up one part of a stew to another, one part of the land or a certain significant section of the land to another stew. That also can be a means of what? Acquiring allodial interest in land. So that's what the third point. Let's look at the fourth point. Point 4. By purchase of it by the stew for and on behalf of the community generally. In the case of gift and purchase, the boundaries of said land are given and clearly demarcated by the donor or vendor. Okay, so you saw that we are saying that, and I want to repeat that part again, that sometimes it could also be by a gift. Okay, a gift that a stew may have got a land and probably for the benefit of his subject. So, in essence, all these 4 ways that we've mentioned, by conquest, by pioneer discovery, by an outright purchase by a stew and or a gift, any of these means are how allodial interests are created in land by stews, tribes, clans, families, and this is what we refer to as allodial interest, or the highest form of interest in land. Now, let me just be quick to add that. You will realize that in the statute or in the Act 1036, when we read the section 2, it mentions that it could also be acquired by the state. Sometimes the state can acquire allodial interest in a piece of land by compulsory acquisition. Okay, the laws also allow that. Subsequently, in our lectures, you would see when we talk about compulsory acquisition, the state can acquire an allodial interest, an ultimate interest land, by compulsorily acquiring land. And we have many of the lands here in Ghana that are that the state has an allodial interest in it because it has compulsorily acquired it. So these are some of the situations that we are saying that it could also be acquired by an individual. Remember, an individual can also acquire an allodial interest in the land. Once the options of purchases are available to people, persons can also acquire allodial interest in land. And remember, the gift is not just a stool to a stool. A stool can also gift a land to an individual. A stool with an allodial interest can give land to an individual. That kind of gift, depending on the conditions that attach to it, could also create an allodial right or title in that individual who has acquired it. So basically, when we refer to the allodial title or the allodial interest in land, which the study has helped us to understand that it is the highest interest in land. And we've seen ways of acquisition. It goes without saying that the way you acquire it, you could equally also lose it the same way. So allodial interest could also be lost through conquest. Okay, if you have an allodial title holder now, and let's say he goes into a tribal war with another tribe, or individual or some other group, and the group were able to defeat the first allodial title holder, they would naturally, of course, take over the land, and they will now be the allodial title holder. So all the means of acquisition of allodial title interest logically means that they are also means of losing allodial title. I think that is very straightforward, and it doesn't beg of any controversy. So that is essentially what we mean by allodial interest in land. Now, in a very famous case, which we call the Ohimin versus J case, that one is also an old case, the West African Law Reports. If you look at it, it's also available on the site. You can look at it, or you can just search it. So the Ohimin versus J also explains most of the ranges or how allodial interest or other forms of interest in land could be lost. And much of these points that we are referring to, as in the way you could acquire the land by conquest, you could equally also lose it through the same means. When you read the case of the Ohimin versus J, you'll find it. It's also available on our website, slpghana.com. You can check that out. Okay. A very important quote that we need to understand when we refer to the conquest and settlement is this. In the case of conquest and settlement, the territorial limits of the stool are determined by the extent of land occupied by its subjects and groups of subjects. Example, families, quarters, tribes, or subdivisions under the stool. You saw that key point. So we are saying that if there is conquest and settlement, the boundary of the land or the extent to which a stool could create or claim allodial interest in the land, it is to that extent where the subjects or tribes are occupied. So if, for example, you have a space here, let's say an area of, let's say, 4 square kilometers of a sort, and there is a conquest or some kind of pioneer discovery or settlement, and you go there, the allodial interest is only available or is only exists to the extent to which the subjects of the stool occupy. So the parts of the land where the stool subjects have never occupied, the groups or tribes have never occupied, they've never done any farming work, they've never shown any interest or taken possession anywhere thereof, does not constitute conquest and settlement. So, for example, if we have tribe A, and tribe A goes to conquer an area, let's call the area B, okay? For the whole of area B to be said to be under the allodial title holdership of A, then it means that all the areas within B should necessarily be occupied by farming purposes or other forms of possession by the subjects and indigents of that. That is a very key point that we need to do there. Now, this is because, for example, you, the students who may be taking exams either at your faculty levels or your Ghana School of Law entrance exams, these are things that you need to know. These are some of the qualifications that have got to do with the allodial title interest. So at this juncture, I think we've clearly reviewed the concepts or the law governing allodial interest in land in Ghana. We've seen that when we talk about an interest in land, we are referring to the rights that an individual or group of persons may have in land, the rights that the law can offer protection to. And we are saying that some of these rights, or one of the interests that you can have, is what we call the allodial interest. Section 2, we've reviewed it, of the Lands Act, Act 1036, and we are saying that it is the highest or ultimate form of interest in land. That is, nobody can claim a superior title or interest to an allodial title holder. It doesn't exist. If you are the allodial title holder, then you are there. Okay, you are there. What they call in the local parlance, boss back or pay. Beyond you, no one else can come. Yeah. So that's what the allodial title holder is. We've seen how an allodial title or allodial interest could be acquired: conquest, pioneer discovery, outright sale, gift, and the persons who can have rights to allodial interests: tools, lands, clans, families, individuals, states by compulsory acquisition. And we also mentioned that the way in which we acquire allodial interest could also be the same way in which we may lose allodial interest. And that is it. In our subsequent videos, as you'll be watching, we'll come to see the effect of the allodial title holdership under an action for declaration of title to land. If a matter goes to court and someone is alleging that a land belongs to me, how does that subject or that interest of the allodial title have a bearing on the way the courts will determine that matter? We'll look at it. Then also, we'll discuss some further ways of alienation of land or land or stool property. That also has a connection to most of these concepts that we have discussed. I hope you've enjoyed the video. Keep watching.